Hello, and thank you for joining us for the next session of the Destination IP Virtual Summit. In this session, Theresa Stadheim will discuss drafting your patent specification to avoid common problems with 35 USC 112. A recording of the webinar and the slides will be made available to all registrants. Feel free to enter any questions using the Q&A feature in the Zoom menu. Also, feel free to follow us on LinkedIn to see news about other upcoming webinars. Our speaker today will be Theresa Stadheim. And with that, I'll hand things over to Theresa.
Thanks, Michelle. Next slide, please. So this presentation was originally a three-part, 3-hour series on 35 USC 112, A, B, and F that I gave for the summer associates at Schwegman. So I'm boiling it down here to the highlights. We will discuss each of 35 USC 112, A, B, and F. And in each section, I will go over the law itself, including the statute and MPEP section. Then we will go over recent case law. Finally, I will provide practice tips that we can glean from case law and from prosecution practice. Next slide, please. First, we start with 112A. Next slide. Here is 35 USC 112A, which is the relevant statute covering written description, enablement, and best mode. The enablement requirement requires the inventor to describe his invention in a manner that would allow the person of ordinary skill in the art to make and use the invention. The best mode requirement is shown here for completeness. However, while this is still in the statute, it doesn't really seem to have teeth anymore, and it never comes up in my practice, so I won't spend further time on best mode, except to say that I would usually spend at least some time thinking about best mode so I know how I want to claim and describe my invention. Next slide. The third requirement of 35 USC 112A is the written description requirement. While the written description requirement is separate and distinct from the enablement requirement, it seems to get conflated a lot in the patent office. I have to say I can sympathize though if there is a confusing interplay between these two. And basically, the Federal Circuit itself even said the two requirements are intertwined. Basically, the written description requirement has historically been confined to making sure that what was originally filed in the patent application is adequately defined the full parameters of the invention being claimed. Next slide. Regarding written description, what you include in your patent application defines the possible extent of the exclusive rights you will obtain and nothing more. That's kind of the hook of written description in the claims drafting. You need sufficient written description for what you're claiming. A telling difference between enablement and written description is that you can bootstrap knowledge of one of skill in the art into your app for enablement purposes, but no such bootstrapping is allowable for written description purposes. If you leave something out, it is not part of the written description, even if someone of skill in the art could understand that you left something out. This ties into a little bit with functional claiming concepts in the computer arts and electrical arts, which we'll discuss more later. Once it is known what's in the four corners of your patent application, the law turns to the enablement question and asks whether one of skill in the art would know how to make and use the invention. In this regard, the written description requirement and the enablement requirement are similar and directly related, yet separate requirements. The next slide. So now that the difference between written description and enablement is clear as mud, let's turn to patent examination. The Patent Office will examine this section of the statute and all other sections of the patent statutes according to the Manual of Patent Examination Procedure, or MPEP. And MPEP 2161 starts the discussion of how patents should be examined with 35 USC 112A. It can be summed up this way: an inventor must describe his or her invention in writing sufficiently to show that the inventor had possession of the claimed invention. And next slide. So speaking of the Patent Office, it reminds me of why we have a written description requirement and an enablement requirement. It's because if we didn't, the whole Earth might be hit by an asteroid and Earth was no, it would end. Just kidding. So I don't know if you guys remember Armageddon. That's the movie with Billy Bob Thornton and Bruce Willis. And I was still an engineer when I first saw this movie, but when I saw it again later as a patent attorney, I was struck by something, that this patent probably would have been rejected under 35 USC 112A, and I think specifically the enablement requirement. If you recall the plot of that movie, Bruce Willis was the patent holder, and in an attempt to make his invention, mysteriously showed up with NASA. And Bruce asked Billy Bob, who's at NASA, whether he stole the keys to the patent office. And Billy Bob fessed up to this, but said that 50 Nassau scientists still couldn't make the invention based on the description and the patent application. Therefore, he needed Bruce's help to make the invention. I say that's a good sign of lack of enablement, but that's just my opinion. Anyway, moving along from my movie review, next slide. The MPEP notes that there are 3 separate requirements under 35 USC 112A and gives further examples helping to illustrate the difference between written description and enablement. Next slide. MPEP 2163 provides detailed guidance on written description. Written description will usually come up when determining whether there's support for claims in a continuation or when claims are amended. However, written description may arise even for original claims. There were guidelines provided to the examiners to examine claims for compliance with 112A. And there's a presumption that an adequate written description of the claimed invention is present and the spec is filed. So if the examiner thinks otherwise, he should raise this right away. Applicants should show support in the original disclosure for new or amended claims. The examiner is supposed to determine what each claim as a whole covers separately, given its broadest reasonable interpretation, which is a whole separate can of worms we won't go to here. It's a whole different area of law, basically. So one issue discussed in 2163 is that the idea that if you're going to claim broadly, you should have broad written description. In other words, if you're only going to describe one specific example in your spec, you shouldn't try to claim broader than that. Of course, this is a fine line, and I am not sure it's held too strictly, at least in the patent office. What I usually would do is I would describe one embodiment very well, and then think one level broader than that, and add language to the effect that examples are described, but other implementations are possible. Next slide. So that's a quick summary of how patent examiners will examine for written description. Next, we'll talk about enablement, which is the second part of the 3-part 35 USC 112A. So examination is described in MPEP 2164 for enablement. And the standard for determining whether the spec meets enablement was formulated in a 1916 court case, which generated the list of undue experimentation factors known as the Wands factors. These take into account the level of one of ordinary skill in the art, the state of the prior art, whether there are working examples, and other factors. Enablement will also depend on how predictable the art is. The less predictable it is, the more guidance is needed in your description in order to meet enablement. And the spec needs not disclose what is well known to those skilled in the art, and preferably omits that which is well known and already available to the public. And I think here an example, a counter example to this is specifications I've seen before. They're 90, like really long, and they kind of read like a programming textbook that we used in Computer Science 101. That sort of thing would be including too much of what is well known, and I would avoid that. And so in electrical and computer arts, if you have a block diagram, the examiner should focus on each of the individual block element components. If more than routine experimentation would be needed to implement such components, then an enablement rejection might be made. If the blocks can further be broken down, I would recommend you to avoid enablement rejection, try to break down blocks as far as you can. I mean, within common sense. What you should do here is have a boilerplate that you use. And if you think a block is very novel and very specific and it's not described well in your boilerplate, then make another block and fully describe that with the inventor's help if you need it. It's good practice to get all this done up front, as it's almost impossible to fix this after the fact, because you could create a new matter rejection and lose your priority date. And regarding enablement, issues could come up when ranges are claimed. When a range is claimed, there must be reasonable enablement of the scope of the range. One example is given in the MPEP of a claim in a chemical compound case that encompassed amounts of silicon as high as 10%, but the spec included statements clearly and strongly warning that a silicon content above 0.5% caused problems. So obviously they weren't enabling everything from 0.6% to 10%, even though they were trying to claim up to 10%. And one final point, a feature which is taught is critical in the spec and is not recited in the claims might result in an enablement rejection. I don't see this rejection much, but at the same time it does come up, and I would avoid, one thing you should do is avoid saying critical or essential in your spec. Then you can just avoid this problem altogether. Next slide, please. Now we'll look at a couple cases that I thought were interesting. The first is Quake versus Lowe, which teaches the importance of robust written description. And here, in this case, Quake amended his claims after Lowe published his patent application because Quake was trying to capture some of the ideas in Lowe's patent. and this created the mismatch between the claims and the original spec. The claims were invalidated for written description because Quake was trying to assert that which it did not possess. One place this might come up is in standard setting environment when competing patent applications are being considered for a standard and they have somewhat similar scope and just kind of overlapping a scope and that sort of thing. And arguably, a competitor might adjust their claims to cover a competitor's patent. In this case, the spec would be analyzed in great detail for written description, and you could get into some written description issues there. The next case is no nouveau. In this case, the Federal Circuit reversed the determination that the claimed invention was adequately described. And here, Nouveau's expert identified portions of the spec that he said supported the claims, but the Federal Circuit disagreed. It was noted that the written description requirements aren't automatically met just because the words of the claim appeared word for word in the spec. Now here, the spec did include the claim language, but provided nothing more than mere assertion that the invention might work, even though persons of ordinary skill in the art would not have thought it would work. Therefore, it did not demonstrate anything more than a wish and a prayer of possession. It did not possess written description. Next slide, please. And then I'm going to go over these next couple cases pretty quickly. In Centrac, the Federal Circuit explained that the level of detail required to satisfy written description varies depending on the nature and scope of the claims and on the complexity and predictability of the relevant technology. And we kind of talked about that a little bit earlier too. And then the D3 Enterprises, the Federal Circuit affirmed invalidity because the patent claim provision or priority to provisional that lacked written description. Here, the description would have had at best led the reader to speculate as to the modifications that the inventor might have envisioned but failed to disclose. And then finally, Adenex. Again, the Federal Circuit found a lack of written description here. The claim was directed to a method for treatment of Hep C and comprised administering an effective amount of a particular drug or pharmaceutical equivalent thereof. And here the spec provided no indication that anything out of the specific disclosed formulas could be effective to treat Hep C, much less any indication as to which of those formulas would be effective. And the patent provided adequate written description for the compounds, but provided no method to distinguish what was effective from what was ineffective. And next slide, please. I was going to quickly sum this one up. This one was involved Biogen, a treatment. This involved a patent for treating MS, and here FWP modified their claims, which were directed to a different disease to track Biogen's patents. And here the spec didn't go into detail on MS and gave no dosages. So the Federal Circuit said the claims failed on written description. Next slide. And then Everlight. Everlight was held to have infringed the patent directed to the preparation of monocrystalline films for use in light-emitting diodes. And here the claim at issue is shown, and the terms grown on and non-single crystalline buffer layer were at issue. And the Federal Circuit thought there were 6 possible permutations for growth layer and buffer layer in this claim. And so Everlight argued that one of those permutations was non-enabled, and that's what the rest of the decision focused on. So ultimately, the court concluded that the patent needed to enable all 6 permutations, and that was a result consistent with the claim constructions that Boston University had sought in the first place. And so stated differently, if you get the claim scope you asked for during the claim construction, you're also going to need to show enablement of that full scope. The skilled artisan's knowledge can fill in gaps between embodiments and sometimes extrapolate beyond disclosed embodiments depending on the predictability of the art. However, this is only supplemental. This gap filling is only supplemental, and it's not a substitute for an enabling disclosure. Next slide. We're going to skip over this one. I had done a little research using a PTAB tool I have, but I think we'll skip that one. Go to the next slide, please. Then I wanted to get through some tips on written description and enablement. And in summary, here's some of my tips. Watch for conflation of enablement and written description rejections. This came up in a couple cases we discussed, particularly Nouveau, and it also comes up with some of the PTAB decisions I saw. So I really hold the examiner's feet to the fire on this during examination without, however, saying anything too limiting on the record about that. And don't omit essential features from the claims. I guess when we're around this, like I mentioned earlier, don't say something is essential in your spec. especially if you're not going to be claiming it, because you'll run into enablement problems. And show support for any of your amendments. I always make it a practice when amending to use exact language from the spec and provide a paragraph number, because a lot of examiners will really scrutinize amendments like this really closely, especially when they think the amendment will overcome the rejection. And link clean language to your specification. Despite what we learned a nouveau above, it can't hurt to use the exact claim language in the spec. You can always use additional language, but at least make sure you minimally use the exact claim language. And I usually use a tool for this as a sanity check when I'm done drafting a case. I find this forces you to make sure I describe everything at least somewhat. And then also, if you think there's a term you use, if you're working on standards cases, something like the cellular communication standard, something like that, I try to provide a lot of synonyms for things in the specification, because you never know which direction it's going to go, and you try to like think in the future. And then next slide, please. Next. And then one tip regarding enablement rejections. To be honest, I don't see many enablement rejections in my area. And a couple of points that might come up in the computer and electrical arts. If you have method flowcharts, describe exactly what circuitry will perform each of the operations in their method flowchart, and make sure whatever it is actually capable of performing that function. So usually for software, it'll be some sort of processing circuitry. And this also ties into functional claiming and indefiniteness that we'll discuss later. Also related, consider providing computer code for really critical limitations or pseudocode, keeping in mind this might be a trade secret. If so, you want to, if you think it might be a trade secret, stick to pseudocode, or even advise that the client consider trade secret protection instead of patent protection. Next slide, please. So setting aside 112A, we'll move on to 112B, which is the relevant statute covering definiteness. Next slide, yep. And so 35 USC 112B is shown here, and patent claims must follow certain rigid rules in terms of format and language. The good news is that in most cases, indefiniteness issues may be resolved by a fairly simple response, correcting whatever objections the examiner had. Basically, it boils down to unclear language most of the time, but it could get more complicated if there are functional claiming issues, so the rest of this will be discussing indefiniteness and functional claiming pretty much. So if the examiner is having difficulty understanding what exactly is being claimed, then an indefiniteness rejection with a request for clarification might be made. In response to such objections, the applicant might want to clean up the claim language. And I would also maybe explain why some features are, or explain some of the features, but that's probably best done in an interview rather than on the record. Next slide. In MPEP section 2171 starts the discussion of how patents should be examined for compliance with 112B. And there are two requirements stated. First, borrowing off the statute we just looked at, the claims must set forth the subject matter that the inventor regards as the invention. Second, the claims must particularly point out and distinctly define the metes and bounds of the subject matter to be protected by the patent. So the first requirement is subjective, and I won't spend a lot of time discussing that as it doesn't come up often. Next slide. But the second requirement might be more objective. So to decide whether the claims meet this requirement, the examiner will determine whether the scope of the claim is clear to a person of ordinary skill in the art. In other words, the claim has to be precise, clear, correct, and unambiguous. The claim scope has to be clear. So to examine claims under 112B, a claim interpretation must be performed. And the underlying principle here is that applicants can draft claims in whatever terms they choose, so long as any special meaning assigned to a term is clearly set forth in the spec. Then the examiner has to interpret the claims using broadest reasonable interpretation, which is more affectionately known as BRI by those in the know. And this is almost a separate area of law in itself, as I mentioned earlier, but what it boils down to is that a claim must be given its broadest reasonable interpretation consistent with the spec, as it would be interpreted by one of ordinary skill. Words are given their plain meaning, which boils down to the ordinary customary meaning as evidenced by a variety of sources. Some of the sources are the words of the claims themselves, the spec, the drawings, and the prior art. The best source and the source most used is the spec itself. In other words, the spec should serve as a glossary for claim terms. Some people even add an actual glossary into the spec, but I haven't done that myself, and I probably wouldn't do that myself. And in my experience, when the BRI issue does come up, this is, the examiner will say he's applying a broadest reasonable interpretation. And this is, in my view, this is usually a sure sign that the examiner is not in fact applying a broadest reasonable interpretation. Typically, I'll get an overly broad, unreasonable interpretation. And this has led to some very interesting prior art being recited against me, but that's a story for another time. So in general, the examiner will look for claims that are clear and precise. Indefiniteness is evaluated in view of the spec, the prior art, and how one of ordinary skill in the art would view the claims at the time the invention was made. The bar is not supposed to be very high, and it's not supposed to be based on personal preference of the examiner, but rather to make sure that someone could figure out whether they were infringing a claim or not. The examiner is supposed to be particularly clear on the record with these sorts of rejections. One thing to watch for here is claim interpretations that are made after an examiner interview. I've sometimes seen it happen right before allowance, and the examiner will go on the record and the notice of allowance stating what interpretation he thinks you came up with in an interview. And if you disagree with this interpretation, you may want to consider calling the examiner up or just making a response, say something in a response to the notice of allowance. The examiner is also supposed to resolve minor indefiniteness issues with examiner's amendments or other interview types rather than resorting to rejection. So this is like the compact prosecution. You want to clear up anything that might be minor regarding indefiniteness up front. And I find if there's any question whatsoever on claim interpretation or indefiniteness, I have an interview to clear it up right away before filing any sort of response. More points regarding clarity and precision. And these points also come up in some of the court cases we'll discuss. Relative terms and terms of degree are not necessarily indefinite. When a term of degree is used in the claim, and a lot of these examples are also set out in the MPEP. There's a lot of examples given about ranges and different clarity rejections that could be made. And for example, when a term of degree is used in the claim, the examiner should determine whether the spec provides some standard for measuring that degree. If the spec does not provide some standard, a determination must be made as to whether one of ordinary skill could still understand the scope of the claim using that claim term. The claim is non-indefinite if the spec provides examples or teachings that can be used to measure a degree, even if there is no precise numerical measurement. And another thing you could do is, if you do get such rejection about numerical measurements, you could also try submitting evidence that someone of ordinary skill could ascertain the meaning of that claim term for the relative term that you have. And a couple more points regarding clarity and precision. Estimates of variables in your claims may be okay. For example, there were some cases I saw that if you have a variable spacing, a relationship between two objects, as long as there is a way of measuring this spacing, you shouldn't have any indefiniteness problems. On the other hand, if the spacing is based on some sort of variable size of the two objects, the claim might not be definite. And approximation words such as about and essentially can be okay. However, if there's close prior art and your approximations are in one of your critical limitations, you want to be more exact in your spec or possibly be prepared to narrow your claims and amendment. And numerical ranges and claims are usually okay with respect to definiteness. However, use of a narrow numerical range that falls within a broader range in the same claim may render the claim indefinite if the boundaries are not discernible. Examples of preferences are given. Some more examples are given in this section of the MPP also. Next slide, please. Now I'd like to discuss some recent indefiniteness case law. A lot of the cases in the next few slides have the common theme that mathematical precision isn't necessary to define terms of degree in order to avoid indefiniteness. In other words, a claim can be definite without mathematical precision. And I'll point out some of the highlights in the next few slides. The first was BASF. And what was important in this one was that one of ordinary skill would be able to figure out which compositions were covered in the claim language, and therefore there was no indefiniteness. Here the spec made clear that it's the arrangement of the catalysts rather than the selection of the catalysts that was important for performing the claimed function. In other words, the claims and spec made it clear that any of a particular group of catalysts would be fine as long as they could play their claimed role in the claimed architecture. And then 1E way, this one I found a little bit surprising, the terms virtually and free from interference were at issue. Here the spec provided guidance to understand that virtually free from interference required that users of the invention do not hear each other's transmissions. The claim also named the source of the interference. The court also did in their trouble with the word virtually, which I found sort of surprising. because there's no numerical definition given, but the user experience that they described made it clear what virtually meant. The court said that lack of a technical measurement does not render the term indefinite. Lofty batting was found to be indefinite at the ITC because lofty was considered the term of degree without sufficient boundary. And the Federal Circuit disagreed because some objective measures were provided in the spec. Also, there doesn't need to be higher degree of numerical definition to make such terms of degree definite. Next slide, please. So in the interest of time, we could sum up the cases in this slide by further reinforcing that mathematical certainty isn't required. But quickly on each of them, substantially naturally appearing. Here they mentioned the specification described QA people in a factory that were looking at, I believe it was furniture, to see if it looked naturally appearing enough. So they were saying, like, does it seem naturally appearing to a person looking at it? And that was considered sufficiently definite. The next one is substantially filled. Similarly, they gave criteria for what substantially filled meant. And then finally, substantially straight. This is like one of the points we discussed above. They described how parts had to be straight enough that they could extend to meet each other. And there was also drawings showing such parts. So just by using the word substantially straight, the claim term was not indefinite. Next point, next slide, please. And we'll just discuss some highlights on this slide. I want to just talk about Nevro real quick. I thought Nevro was interesting, particularly with regard to configured to. It's a term I use a lot in my claiming, especially for processors and software. It was argued here that the term configured to could be construed as two possible things. Either the apparatus had the capacity to do something, or the apparatus was programmed to do something. Because the term is susceptible to two different constructions, the district court concluded that configured to made the claims indefinite. That was actually held up in a lot of claims I write would be in trouble because I use it a lot. So luckily for us, the Federal Circuit said that this was an incorrect legal standard. And like I was saying, applying such a standard would make nearly everything indefinite. And mastermind I also thought was interesting. In mastermind, the district court held that the claims were indefinite for being improperly directed to both an apparatus and a method. And the Federal Circuit disagreed with its indefiniteness finding. It said that while a claim directed to both a method and an apparatus may be indefinite, apparatus claims are not necessarily indefinite for using functional language. Next slide. And highlights in this slide, I'll just talk about trusted night briefly here. The trusted night case was important because of missing words. I don't recall exactly what missing word was here, but basically trusted night tried to claim there was an obvious error in the claim language due to a missing word that was making this claim term indefinite. However, the court found this could not be fixed in a patent infringement suit because the correction was subject to reasonable debate, and the prosecution history did not suggest a different interpretation. The moral of the story here is to make sure you don't have missing words. Okay, you can stay on that slide for now. So next I'd like to go over some practice tips. The most important practice tip, at least in the computer arts for indefiniteness, is to spell out exactly how any novel function will be done, preferably in a flowchart or pseudocode. I'll often use a flowchart and then refer back to very detailed equations or pseudocode for each method block in the flowchart. One way to go about this, if you are drafting the case from scratch, is to really hold the inventor's feet to the fire and have them spell out an algorithm for you for every method step. As one of my mentors told me, don't let the inventors get away with any hand waving. He has some good motions for that. I can't really show you now. But anyway, and then so the next hint I would give you is watch out for examiners who are too formulaic about antecedent basis. I've seen this in my own practice pretty often. I think it comes about when examiners get 112B training or something like that. I see this more. But I'll start off drafting the claim that makes sense. And some examiners will be very formulaic about adding the word a somewhere, which renders the claim language into gibberish. This kind of goes against the whole idea of making claims clear and goes against the spirit of 35 USC 112. And then regarding claim language, remember literal support is not required in the US, but make sure that things are at least understandable and consistent. And there are tools for checking for inconsistent language. For a cautionary tale, see Trusted Night that we just discussed. And then remember ranges. You don't have to be 100% strict on the exact range. Try to give some range or measure for comparison. None of the cases in which mathematical precision for measuring things isn't necessary. In terms of degree, may be okay, but make sure you at least have some sort of figure or range or criterion in your specification. Next slide, please. Next, we'll move into a discussion of 112F, most specifically functional claiming. We'll go over the law itself, including the statute and MPAP section. Then we'll go over recent case law, looking at practice tips that we can get from each. So here, functional claiming made its way into the patent law in response to a 1946 case called Halliburton versus Walker, which held the patent invalid because the patent owner did not describe the invention, but used conveniently functional language, describing what the apparatus would do rather than the physical characteristics or arrangement of the new apparatus. There was a bit of a public uproar after that case for being unduly limiting the patent rights. Functional claiming was now allowed, but the scope of such limitations was restricted to the structure and equivalence of the structure disclosed in the specification. Next slide. Here we see the statute as it is currently. If a structure is not in the claim is construed as covering the structure and equivalence described in the specification. So how do examiners interpret the 112F statute? Next slide. The plain meaning of any terms is used to determine whether those terms would be interpreted as sufficient structure to avoid 112F interpretation. Next slide. It's important to remember 112F is not a rejection. Instead, once the examiner decides structure is not in the claim, in other words, once the claims are subject to a means plus function interpretation, the claims are examined to see if they comply with other 35 USC 112 requirements, including the definiteness requirement shown here, and which we had also described previously. So the spec must adequately describe structure for performing the claimed functions. This can mean different things for different kinds of inventions, as we'll discover in the rest of the presentation. Written description rejections or 112A rejections may also be seen with 112F, but in my experience, it's more rare, so we're focusing on 112B for the rest of this. For example, written description rejections might come up in functionally claimed computer inventions if you're trying to claim any means for doing a function, but you only describe one in the specification. Remember that this is an issue because it does not give notice to a potential infringer that you have possession of all means for doing a function. In other words, the potential infringer doesn't have notice of the true breadth of your invention. Similarly, claims may lack written description when the claims define the invention in a functional language, specifying a desired result, but the spec does not sufficiently describe how the function is performed or the result achieved. For software, this can occur when the algorithm or steps for performing the computer function are not explained at all or not explained in sufficient detail. In other words, if you simply restate the function recited in the claim, that's not sufficient. In other words, the algorithm or steps taken to perform the function must be described in sufficient detail so that one of one skill in the art would understand how the inventor intended the function to be performed. Next slide, please. So in January 2019, the PTO provided draft guidance on examining computer-related functions for 101 and 112. And lately, I know this isn't a coincidence. So lately we've seen a trend in which we get 101 rejections that look more like 112F interpretations, followed by different 112 rejection, like 112B. This is because, in my opinion, at least the way I look at it, when you have a structure, when the structure is unclear or lacking, it can look like the claim is abstract, which we all know is the kiss of death for some claims, particularly software claims. So for this reason, it's considered noteworthy, and it's not a coincidence that 101 and 112 guidance were posted on the same day. And Bob Barr actually said that this was on purpose and acknowledged that the two were sometimes conflated. He said basically some issues raised under 101 were better dealt with under 112 analysis. And in order to provide a complete answer to both the subjective matter eligibility and 112 rejections, the Patent Office released both Federal Register notices on the same day with the hope that 112 would reduce some of the 101 issues seen with the Patent Office. Or with the hope that the 112 Federal Register notice would reduce some of the 101 issues. And additionally, Mr. Barr encouraged practitioners to submit comments regarding the 101 and 112 Federal Register notices. And a training video is actually provided to the examiners in March 2019. Next slide, please. In the training, the examiners were reminded that it's important to recognize which claims limitations invoked 112F because this governs the broadest reasonable interpretation of the claim. And accordingly, that determines what field of prior art you're going to look at and which art you're going to get in your 103 or 102 rejections. And the training reiterated the three-pronged test that was in MPEP 2181. Namely, according to MPEP 2181, a claim limitation should be interpreted according to the 112F. If it uses the term means or a generic placeholder for the term means. If means or the generic placeholder is modified by functional language linked by transition word, and if the term means or placeholder is not modified by sufficient structure to perform the claimed function. Next slide, please. And the gist of the training, at least according to some anecdotal evidence I gleaned from different examiner interviews, is does it make sense for the structure to perform the function? If yes, the examiner probably won't complain. It probably won't give you a 112F interpretation. So example, if you're claiming a blender to blend, you're probably not going to get a 112F interpretation. Or if you're claiming something like a flux capacitor to blend, then you'll probably run into 112F issues. So congruency, basically they're saying congruency between the structure and the function is a good rule of thumb. As long as you have that, you should be okay. Another thing to keep in mind here, although the training mentions dictionaries, it is best to start off arguing plain and ordinary meaning. I find if you're getting into the weeds or looking at the dictionary definitions during prosecution, this isn't a good sign. Also can be helpful if the prior art uses the exact terms and describes them as structure. I've seen that happen more than once as well. We had a couple rejections. I remember some rejections where they would interpret something as structure and the 103 references and then turn around and say that it wasn't structure in our own application. And so you could use that as an argument also. It is also worth noting that whether a claim term will invoke 112F is rather arbitrarily decided. It got especially arbitrary after the Williamson case that we're going to discuss next. Next slide, please. So in practice, up until the Williamson case of June 2014, you could typically avoid a 112F treatment just by avoiding the word means. However, when Williamson came out, software claims started receiving a harsher treatment and were interpreted under 112F even if applicants did not want to attend that. So an applicant who did not want, applicants who did not provide structure might find themselves unbind because the 112F interpretation could open the door for problems with other 112 issues, especially indefiniteness. In addition, Williamson is the highlighted claim term shown here. The patent described methods for distributed learning that utilize industry standard software and hardware linked by network to provide a virtual classroom environment. That's something that would probably come up a lot now. Originally, the court found that the term module did not invoke means plus function, but Citrix sought an en banc review. Sitting en banc, the court withdrew the earlier opinion and reversed earlier precedent, creating a strong presumption that the limitation does not invoke 112F if the word means is not used. Instead, the new standard would be whether the words of the claim are understood by a person of ordinary skill in the art to have a sufficiently definite meaning as a name for a structure. Here, the word module did not indicate structure and set forth a black box recitation of structure. Court looked into the spec for corresponding structure and did not find it. Therefore, they found the claim indefinite. The written description also failed to impart any structural significance to the prefix here. So distributed learning control did not make it look any more structural and did not help their cause. Next slide, please. After Williamson, there's no longer a heightened requirement for evidentiary showing that a given term invokes 112F. Some of the next cases which came up after Williamson show some surprising and unsurprising instances in which terms were subjected to 112F. So the first slide shows some examples in which terms did invoke 112F. So in M2D, the issued term was the term at issue was mechanical control assembly. And the Federal Circuit found the PTAB gave undue weight to the patent's prosecution history and reversed the finding that 112F did not apply. So in an IPR for this case, the patent owner M2D introduced expert testimony indicating that mechanical control assembly had no reasonably well understood meaning in the art, and Toro disagreed. Toro was brought the IPR. And the PTAB found that 112F did not apply due to statements made during prosecution of the patent. and where MTD argued that the term did in fact connote specific structure. And MTD had argued that the claimed mechanical control assembly was structurally different than disclosed in the prior art. So therefore, according to PTAB, MTD was admitting that mechanical control assembly was structure, and therefore 112F could not apply. And the Federal Circuit reversed, stating that prosecution history doesn't matter. And what does matter is whether the claim term is used in common parlance or by persons of skill in the art to designate structure. And here, if the claim is drafted in means plus function format, the second step involves review of the spec to identify the structure that performs the claimed functions to figure out whether indefiniteness applies. And the Federal Circuit cautioned that these two inquiries were distinct. The other cases, I don't think are very surprising because they use check standby unit. To me, that doesn't denote structure, and customization module, which we saw module didn't denote structure pretty commonly. So I'm just not going to talk about the next two. Go to the next slide, please. A zero click was a big turning point for, at least in the software arts. Program and code were found not to be functional. And the Federal Circuit here found that the district court's ruling was very conclusory, basically accepting Apple's interpretation that those two terms were not structural. Second, the district court's analysis removed the terms from their context, which otherwise strongly suggests the plain and ordinary meaning of the terms. So they cautioned against taking terms out of the context. The terms at issue were tethered together and further tethered into processors and memory, which are very physical and very structural. And one of ordinary skill would also be able to discern that the terms were not black box recitations, but rather specific reference to conventional graphical user interface programs or code. And then Sky appealed an IPR decision that the patent was obvious. And here they wanted the claim term wireless device means to invoke 112F for some reason. And I think, yeah, they were trying to distinguish over prior art by importing limitations from the spec into the claims. So basically they wanted to have to look into the spec to interpret what that word means in order to get over the prior art. The Sky argued that corresponding structure of wireless device means, as described in the spec, having multiple processors, which were missing in the prior art. And the Federal Circuit didn't buy that argument. They said, well, the term wireless device is used to designate structure, and the claim did not recite any functions performed by wireless device means. And the claim to term wireless device means is not linked to or associated with any functional language. Instead, the claims merely recited wireless device means as a recipient of media files transmitted from one or more servers. So here these people, they actually wanted to get 112F interpretation and even use the word means in the claim, and they did not, the Federal Circuit did not think that should invoke 112F. So I thought that case was pretty interesting. And then FinGen was also interesting to me here. So in FinGen, there's a content processor. Oh, next slide, please, sorry. The content processor and downloadable scanner both had tangible examples in the spec, and there was a reliance on expert testimony, and the definition of downloadable was agreed upon and was structural. I thought that was a bit surprising that they found downloadable to be structural, but they did. And then in VR optics, the terms at issue were logic and logic configured to. And logic connotes structure even if it's broad, and no evidence was offered to the contrary by Peloton. And VR also offered a declaration to that effect that logic was structural. Furthermore, logic in the specification was described as being structural components. And I actually use that quite a bit in my A1 specifications too, so I can see that. And then type mock apparatus is found to be a generic term, but structure is claimed in the form of an algorithm, so means plus function did not apply. And what I thought interesting here was there was a battle of the prepositions, it was called. So the claim language was in the following format: an apparatus for doing something by XYZ, where XYZ is an algorithm. So according to type mock, the by phrase sets out the algorithm that performs the function, in other words, the structure. So the algorithm is the structure here. On the other hand, Telluric thought by was just adding to the function. And the court thought type mock had the better of the battle of the prepositions, while for indicates a purpose or goal according to the dictionary. The specification also supported type mock's reading of the claim language. And the processor here was not functional because it is a particular type of computer component. And code also was not structural because it was program instructions. So there's several things that help out people in the software arts and computer arts. Next slide, please. I'd like to wrap up with some practice tips on functional claiming. So some ways to avoid functional claiming is by claiming, assuming you want to avoid functional claiming, which I don't necessarily think you have to do all the time. But assuming you want to avoid functional claiming, show how things are interconnected, either within the claim or to the outside world. For example, using ports, one way is to use ports, or citing other memory right in the claim is helpful. And taking less of a type mock, even though that was only a district court case, use the word by in your claim, followed by exactly how an operation is done. In other words, use the claim format used in type mock. An apparatus for X by Y, where Y is the algorithm. And keep in mind that it may be desirable to use means plus function claiming. Some of my clients even ask me to include a means plus function claim. Keep in mind they often get favorable, broader treatment in Europe. So some of your clients that practice in Europe, you might want to suggest functional claiming to them if you haven't already. Next slide, please. And in general, I try to avoid terms like module or unit, as they seem to pretty consistently invoke 112F interpretation. Same thing that a module can do can be done by a processor or something else that sounds more like hardware. So I try to avoid use something that sounds more hardware-y, like a processor instead of module. At the very least, include language in your spec that says a module can include any circuitry, processor, or even code. For example, we saw in zero-click where code is considered structural. Also, as we noted in the Sky case, that was noted in the Sky case that we discussed earlier. If you're going to include a means plus function claim set, if you do intend means plus function, at least for what you consider the core novelty, make sure you actually use functional language. Don't just say means and then don't have any functional language after that. You can't assume that means is going to lead you to 112F interpretation. Another good practice is to claim as many embodiments as possible for doing something. Keeping in mind we don't get unlimited amounts of time to draft our case, while we're often taught to be as broad as possible in our claiming, at least in the spec it is narrow and specific as needed to really perform the claim functions. This will allow you for more amendment later. And regarding this point, keep in mind that Nevro, which we discussed earlier, also encourages including as many examples as possible in your spec. Next claim, please, or next slide, please. If you find yourself having to argue against functional claiming during prosecution, either amend or show something that the claim elements are connected together to perform something. So either amend to make something more physical sounding, or add some kind of a link between claim elements, add memory or add a port or something like that. And then argue plain and ordinary meaning instead of going off the dictionary. Plain meaning is supposed to come before you wander off into the spec. So just argue plain meaning when you can. And remember, however, that you don't necessarily need to argue or traverse this interpretation unless you got a 112A or B along with this. You may just want to let it be. Don't try to argue against the interpretation. If there's you might even want to agree on the record and point out where the structure is in the spec on the prosecution record. I have had a couple times where the examiner gave me a 112F interpretation, and then I thought they were pointing to the wrong part in the spec where the structure was. If you think they're wrong, you might want to correct that on the record during prosecution. Next slide, please. So in summary, today we covered patent examination procedures and case law in 35 USC 112. And I thought the practice tips I gleaned from this analysis, I tried to gather practice tips based on all that and figured out ways to help you draft your patent applications clearly and in enough detail to effectively describe your invention and get your patent application through to issue. This should also give you good, strong patents for later litigation proceedings if necessary. Thank you for your attention. And that's all I had. Thank you.